and shall do so with liberality, etc. Under this ruling, our Supreme Court held 2005 in the case of Katarungan Planters Development Bank. Under this section that I've just read, if evidence is objected to at the trial on the ground that it is not within the issues made by the pleadings, the court may allow the pleadings to be amended freely when the presentation of the merits of the action will be subserved thereby, and admission of such evidence would not prejudice the objecting party in maintaining his action or defense upon the merit. It is thus clear that where there is an objection on the evidence presented, because it is not within the issues made by the pleadings, an amendment must be made before accepting such evidence. If no amendment is made, the evidence objected to cannot be considered. That is the categorical ruling of our Supreme Court. In the 2004 case, Argente v. Provincial Sheriff, the complaint should state the theory of a cause of action which forms the basis of the plaintiff's claim of liability. The office, purpose, or function of the complaint is to inform the defendant clearly and definitely of the claims made against him so that he may be prepared to meet the issues at the trial. Yan ang batas. Ngayon, ang problema natin, marami kasi ng mga kibitzers mahilig mag-abogaduhan. Eh kung gusto niyo mag-abogado, mag-enroll kayo o kaya magbasa kayo tungkol sa batas. At criticize batikos ng batikos na wala namang base sa batas natin. Gusto ba nilang gagawin sa kanila? Gusto nilang gawin sa ibang tao? That is the basic question. Akala mo kasi, nakikipag-fistballan tayo dito. Hindi. Malaga ang pinag-uusapan natin dito. Hindi tayo nakatayo sa tabi ng fishball vendor at bumili ka ng fishball stick mo at bumili din ako ng akin, tapos kain tayo doon. At maglandian tayo tungkol sa ating mga opinions sa batas. Magbasa kayo ng batas. In short, within the discretion of this court, we can have a continuance, because that's what the law says, to allow the prosecution, if it makes the proper request, to amend their complaint. If they don't, then they simply cannot present the witness because he will testify to a matter that is not alleged in the article of impeachment. That was my position in the Estrada impeachment trial. That is the very same position I take today. Thank you.
Thank you very much, Majority Floor Leader.
Mr. President, we are ready to listen to the presentation of the prosecution for the continuation of their presentation of evidence or witnesses.
The prosecution has the floor. You may now present your witness, if you have any witness.
Thank you, Your Honors. Good afternoon. I speak, Your Honor. This representation speaks relative to Article 3, Your Honors.
Article 2.
Article 3, Your Honor.
Article.
We have reverted back to Article 3 yesterday, Your Honor.
Yes, proceed.
Your Honor, we have concluded the presentation of evidence yesterday with the offer of with the proffer of proof.
Proffer of proof.
Proffer of proof, Your Honor,
Not offer of proof, not offer of evidence.
I
just want to clarify.
Yes, Your Honor. With the offer made by the private prosecutor yesterday, in light of the ruling by this court, Your Honor, that a pivotal witness may no longer testify. That is the last witness we have, Your Honor, for the so-called FASAP case. Now, this is embraced in paragraph 3.1 to 3.3 of the complaint, Your Honor. Just to be very clear. Yes, Your Honor.
3.1
to 3.3 of the complaint.
Just a minute. I want to see the... up to 3.3.
Yes, Your Honor. 3.1 to 3.3, Your Honor.
At any rate, the understanding of the court is the private prosecutor made a manifestation and proffered what he considered to be an evidence. The chair will allow it to stay in the record, but at the time of the offer of evidence, then the matter will be revisited and decided whether it will be admitted or not.
Thank you, Your Honor. Thank you very much, Your Honor. Your Honor,
I just want to put on record with the caveat that Article 3 does not allege any subornation or bribery or any special favor that influenced the thinking, the attitude, or whatever of the respondent. I just want to make that clear so that if you want to strengthen your position, you know the remedies.
Thank you very much, Your Honor. Your Honor, having said that, the prosecution would like to respectfully manifest, Your Honor, that so far as the other wrongful acts stated under Article 3 is concerned, namely, Your Honor, that respondent created an excessive entanglement with Mrs. Arroyo through her appointment of his wife to office, which is embraced under paragraph 3.4 to 3.4.8, Your Honor.
3.4
to 3.4.8.
Yes.
That is the second wrongful instance or wrongful act that we allege, Your Honor.
Yes.
Also, that respondent dipped his hands into public funds to finance personal expenses. This is embraced in paragraph 3.4.9 to 3.4.10.
3.4.9,
Your Honor, to 3.4.10.
Yes.
And finally, that respondent discussed with litigants cases pending before the Supreme Court, which is embraced in paragraph 3.5 to 3.6.5. .5, Your Honor. 3.5 to 3.6.5.
What I have here is 3.6.4. There is
Up to
yes.
Yes.
3.6.5.
Yes.
Yes.
In all these allegations of wrongful acts, Your Honor, starting with 3.4 to 3.6.5, Your Honor, the prosecution respectfully manifests that we are no longer presenting evidence in regard to this.
Are you dropping these matters?
Only with respect to the three wrongful acts alleged in the complaint, Your Honor. But as far as Article 3 is concerned, Your Honor, the case is there. And in support of that, Your Honor, we have the evidence submitted in that so-called FASAP case, Your Honor. To recall, Your Honor, please.
Just a minute, to be clarified.
Yes, Your Honor.
Your allegation in Article
3
is respondent committed culpable violation of the Constitution and or betrayal of public trust by failing to meet the and observe the stringent standards of Articles 8, Section 7, Paragraph 3 of the Constitution that provides that, quote, a member of the judiciary must be a person of proven competence, integrity, and independence, close quote, in allowing the Supreme Court to act on mere letters filed by a counsel which caused the issuance of flip-flopping decisions in final executory cases. Now,
We stop there, Your Honor. We stop there.
you want to maintain this allegation
Yes, Your Honor.
to
Yes,
be
Your
the
Honor.
subject of proof.
Yes, Your Honor. We have proven that already, Your Honor.
Precisely. To be the subject of proof which you will offer at the proper time.
Yes. Yes, Your Honor, please.
Now,
Thank you, Your Honor.
The next charge that you included in that allegation, Article 3, the predicate of your conclusion is that in creating an excessive entanglement with Mrs. Arroyo through her appointment of his wife to office. You are now dropping this.
That's right, Your Honor. We're not presenting evidence.
And you are not going to present any evidence? And this will not be presented to the court for decision?
Yes, Your Honor.
Okay. Then the last one is N. You have a conjunction here, N. In discussing with litigants regarding cases pending before the Supreme Court. You will also drop this
Your
allegation. You will not offer any evidence, and it will not be presented to the impeachment court for decision.
That is correct,
All
Your
right.
Honor. That is correct, Your Honor. That's correct, Your Honor.
Mr. President, Senator Joker
The
Arroyo,
majority floor leader,
Senator Arroyo would like to ask a
the
question
gentleman
on this
from
point.
Makati and Bicol.
Thank you, Mr. President. It's just a simple question. I just ask from the prosecution, anybody can answer. There was a lawyer here that appeared as a private prosecutor. Is he here now?
Yesterday, Your Honor,
Well,
the one that made
yes.
si Attorney Marlon. We're not sure if he's here, Your Honor.
No, anyway.
We will try to answer you.
I just want to ask the question. Is he the lawyer of Palea? Because I received information that he is the lawyer of Palea, meaning the labor union in Philippine Airlines.
We will have to make an inquiry, Your Honor.
All right,
We're
you
not
take your
private.
time. I just want to have an answer on that.
We'll provide you with the answer, Your Honor. Thank you.
Still on the issue, Mr. President, Senator Escudero.
The gentleman from Sorsogon.
Thank you, Mr. President. Some questions to the Honorable Congressman Gigi Agabao, with respect to the statements he made. Do I take it that the prosecution will no longer present evidence aliunde with respect to the other sub-paragraphs of Article 3?
That's right, Your Honor. With respect to Article 3.
But the article still stands?
Yes, Your Honor.
And
Yes, Your Honor.
simply you are resting on the allegations contained in your complaint and will no longer be presenting documentary or testimonial evidence on the matter?
Yes, with respect to the other allegations there, Your Honor. But with respect to the FASAP case, Your Honor,